Très bien. Bienvenue. Je vais commencer en français. Bonjour à tout le monde. C'est un plaisir pour moi d'accueillir le commissaire Reynders, commissaire à la justice, qui nous fait l'honneur de présenter le premier rapport sur l'état de droit de l'Union européenne ici à Bruges, au Collège d'Europe. Quite something, I would say. So if you want to have a look at that, that can be an interesting word for many of you, I guess. I was explaining to the Commissioner, well, first of all, I think the Commissioner doesn't need much of an introduction from my side. For me, in particular, it is a pleasure, honor to host him as the first guest of this academic year. I know that you are also very excited because it's your first event after many weeks of isolation and quarantine. But for me, it's a special day also because with Commissioner Reynders, we shared a lot of Foreign Affairs Council in the past 5 years. So it's for me also an opportunity to see a friend, not only a colleague, and to host an important moment here in the college for what concerns rule of law. I would speak very shortly, actually almost not at all, because I think that we are all here to listen to his presentation and then ask questions and interact with you and with those of you that are following from the rooms. So a special good morning also to all of you that are not be able to be physically present but are following us remotely. This is the new normal we have established by now. But I would just like to say that I'm very happy to have this presentation here because I know how important this project has been for the Commissioner. I can only imagine how much work has gone into this. And for sure, already from the very first days, this has had the advantage, or I would say the positive implication, of putting on the spotlight something that is extremely important, which is, I would say, the internal coherence and consistency of the European Union and its member states to one of the core values of its foundation, the rule of law. I have experienced myself personally how important it is, not only for the internal functioning of our societies and institutions, but also how important it is for the credibility of the European Union abroad, to be able to show that rule of law standards and also human rights standards are high and respected inside the Union. I imagine that the Commissioner will not have an extremely easy task in going forward, not only with the presentation of the report, but then on the following steps. But I can say that I think this is probably one of the most important elements that this new Commission has introduced. And I think it is for us all a privilege to have the possibility to listen from his own words about the report and then to interact with him. I will not use more of your time, Merci beaucoup encore pour avoir choisi le Collège d'Europe pour présenter les rapports. Et je te passe immédiatement la parole. Merci. Et quand tu pars de là, tu peux aussi enlever la masque parce que la distance est suffisante.
Yes, of course. From here, it will be easier. No, Director and dear Federica, first of all, I want to say it's a pleasure to come back here in Bruges, but also to have a new contact with you. Comme tu l'as dit, on a beaucoup travaillé ensemble dans d'autres cadres, et j'y reviendrai parce que le travail que l'on fait dans l'Union, comme tu viens de le rappeler, est un travail important aussi pour ce que nous faisons en dehors de l'Union. Mais merci en tout cas pour cette occasion et cette opportunité de m'adresser à des étudiants, mais aussi aux professeurs, dear professors, but dear students here in Bruges, but also in Netherlands, if I'm well informed. And thank you for the warm welcome with Belgian weather, of course. And thank you to the College of Europe for hosting today's conference. It's a surreal honor for me to be with you and today to present the first edition. Sometimes we have said the first ever, but it's true, it's the first edition of the European Commission's Rule of Law report. The opportunity to hear your views and exchange with you after the report's publication last week, so very rapidly, matters a lot to me. Indeed, it's more important than ever that students and academics reflect on and engage with the topic of the Union fundamental values, and of course, in particular, on the rule of law. I'm therefore glad to have the two campuses of the college, here and in Poland, joining today's discussions. What we'll be doing today is precisely what the report is all about, a debate on the rule of law, engaging people across the Union. Is the first main goal of the report, is to try to install a culture of the rule of law. And to have a culture of the rule of law, we need to discuss in the entire Europe about such a report and about the different remarks that we have present about the different member states. And let me start with a quote from my estimate compatriot, Koen Leenaerts, the president of the Court of Justice of the European Union. Today, Europeans are facing a defining moment in the history of integration. They must stand up for the values, such as democracy, the rule of law, and fundamental rights, that we share in order to emphasize the point that what brings us together remains stronger than what pulls us apart. That is why the principle of judicial independence must be preserved so that the EU remains a union of democracies, a union of rights, and a union of justice. If the next generation of Europeans is to explore new horizons for an ever closer union where citizens may continue to enjoy a sphere of individual liberty, free from public interference, integration through the rule of law is the only one way forward. End of quote. And before getting into the substance of the rule of law report, I would like to ask you maybe some questions here, but also in Natalie. Have you ever worried that judges are not always independent? Have you been concerned that corruption is not prosecuted effectively? Have you wondered whether the media operates freely? Whether NGOs are being intimidated in some of our member states? And if so, you are probably thinking that the European Commission should do more to protect and promote the rule of law. I must be honest, I have had these concerns myself, and I have always thought that the Commission could and should do more. Mon engagement pour le respect de l'état de droit n'est pas nouveau. Tout n'a pas débuté lorsque j'ai entamé mon mandat à la Commission européenne en tant que commissaire à la justice, aussi en charge de l'état de droit au sein de la Commission d'Ursula von der Leyen. Pendant mes études de droit, j'avais saisi l'importance de garantir l'équilibre des pouvoirs, l'indépendance de la justice, la liberté de la presse et, bien entendu, les enjeux démocratiques que tout cela comportait. Et j'ai toujours bataillé et œuvré pour défendre ces principes fondamentaux de la démocratie. Avant d'entrer dans la Commission, et nous avons eu l'occasion de travailler ensemble, Federica Mogherini et moi, mais j'ai pu participer aux travaux du Conseil pendant 40 présidences successives sans interruption, donc pendant 20 ans. Et au Conseil Affaires étrangères, mais surtout au Conseil Affaires générales, on a évoqué à plusieurs reprises la problématique de l'état de droit. En 2016, au début d'année, j'ai déposé sur la table du Conseil une proposition de peer review, de revue par les pairs, concernant l'état de droit. J'ai eu tout de suite le soutien, d'ailleurs, de quelqu'un qui va jouer un rôle dans les prochaines semaines à propos de ce rapport. C'est le responsable en Allemagne des affaires européennes, Michael Roth, qui préside le Conseil Affaires générales aujourd'hui et qui va devoir dès lors se saisir de ce rapport et se saisir du débat sur un certain nombre d'États membres. Et je crois que c'est important de rappeler ce processus parce qu'à l'époque, on parlait difficilement des valeurs et de l'état de droit autour de la table du Conseil. Il a fallu plusieurs années pour convaincre un certain nombre d'acteurs d'avancer dans cette voie, et la Commission s'est lancée aussi dans une communication en 2019 qui se traduit maintenant par ce premier rapport. Et lorsque j'étais, dans une vie encore antérieure, ministre des Finances pendant 12 ans en Belgique, j'ai eu l'occasion de discuter des situations budgétaires et des réformes structurelles lors de toutes les réunions du Conseil ECOFIN ou de l'Eurogroupe. C'était normal de parler des critères de Maastricht. C'était beaucoup plus compliqué de parler des critères de Copenhague. Et donc, pourquoi ne pas avoir le même débat aujourd'hui sur les valeurs que nous partageons, qui fondent l'Union européenne, comme nous avons un débat sur la situation budgétaire ou des réformes structurelles dans l'Union. Et donc, ça n'avait pas encore été possible, et j'étais d'avis qu'il fallait changer cette dynamique. Et j'avais, je le répète, déjà obtenu des soutiens progressivement d'un certain nombre d'États membres. Et je me suis vite rendu compte que le concept d'État de droit, dans ces discussions, n'était pas un concept abstrait, mais bien le fondement et le prérequis de nos systèmes démocratiques. Alors maintenant, permettez-moi de prendre du recul et de commencer peut-être par une réflexion plus large sur l'importance de l'État de droit. Le respect de l'État de droit implique que tous les pouvoirs publics agissent dans les limites fixées par la loi, conformément aux valeurs de la démocratie et des droits fondamentaux, et sous le contrôle de tribunaux indépendants et impartiaux. Je rappelle souvent qu'il faut bénéficier de l'accès à un juge indépendant, si possible, nous y travaillons aussi, qualifié et efficace. L'indépendance ne suffit évidemment pas. Comme vous le savez, l'État de droit comprend différents principes. La légalité, qui implique un processus transparent, responsable, démocratique et pluraliste de promulgation des lois. La sécurité juridique, l'interdiction de l'exercice arbitraire du pouvoir exécutif, la protection judiciaire effective par des tribunaux indépendants et impartiaux, le contrôle judiciaire effectif, y compris le respect des droits fondamentaux, la séparation des pouvoirs, l'égalité devant la loi. Alors, ces principes ont été reconnus par la jurisprudence de la Cour européenne des droits de l'homme et par la jurisprudence de la Cour de justice de l'Union européenne. Un exemple est l'arrêt Les Verts de 1986, dans lequel la Cour de justice a adopté le concept de communauté de droit. Et aujourd'hui, l'article 2 du traité sur l'Union européenne inclut l'État de droit parmi les valeurs sur lesquelles notre Union est fondée. C'est cet article qui constitue la base de notre discussion. Et parmi ces valeurs fondamentales, l'État de droit joue un rôle particulier. Quand j'évoque l'article 2, je voudrais vous rappeler que l'année dernière, lors de l'installation de la Commission, vous avez peut-être vu apparaître un débat sur ce concept de European Way of Life, la façon de vivre à l'européenne. Il y a eu beaucoup de discussions sur ce sujet. À mon sens, la façon de vivre à l'européenne, c'est l'article 2 du traité. C'est là que se trouvent les valeurs qui font qu'on peut développer sa vie personnelle, individuelle, dans le cadre des libertés qui sont garanties, avec les mécanismes qui les protègent en matière de démocratie, de droits fondamentaux et d'état de droit. Et effectivement, l'état de droit garantit la protection de toutes les autres valeurs, y compris, je le disais, la démocratie et le respect des droits de l'homme. Dernièrement, nous avons entendu des voix populistes qui opposent la démocratie à l'état de droit et qui voudraient nous faire croire, qui voudraient vous faire croire, que l'équilibre des pouvoirs ou le pouvoir judiciaire indépendant sont des contraintes excessives par rapport à la volonté de la majorité. Et cependant, notre histoire nous a appris que la démocratie a besoin de l'état de droit pour garantir que les droits de la minorité et des plus faibles soient également protégés. Le respect de l'état de droit est d'une importance particulière pour le fonctionnement de l'Union. Il est crucial pour l'application effective du droit de l'Union. En effet, l'application du droit européen ne repose pas seulement sur la Cour de justice, mais dans la plupart des cas sur les tribunaux nationaux des États membres. Si les tribunaux nationaux ne sont pas indépendants, comment pouvons-nous leur faire confiance pour appliquer efficacement le droit de l'Union européenne? Le respect de l'état de droit est également crucial pour le bon fonctionnement du marché intérieur. Lorsque les systèmes judiciaires garantissent l'application des droits, les créanciers sont plus enclins à prêter. Les entreprises, évidemment, sont dissuadées de tout comportement opportuniste, les coûts de transaction sont réduits et les entreprises innovantes sont plus susceptibles d'investir. En d'autres termes, l'état de droit est important pour un environnement favorable aux entreprises et aux investissements. En outre, le respect de l'état de droit est essentiel pour la coopération civile et pénale efficace entre les États membres, par exemple, lors de l'exécution des mandats d'arrêt européens. Nous avons besoin d'une confiance mutuelle entre les États membres ou, dans le cas du mandat d'arrêt européen, entre les juges. Et la confiance est au cœur du problème de l'état de droit. L'Union repose sur des valeurs, mais l'Union repose aussi sur cette idée que les États membres, les citoyens, les entreprises, tous les acteurs se font confiance à l'intérieur de l'Union pour permettre le développement du marché intérieur, pour permettre aussi la bonne coopération, je disais, dans des domaines judiciaires. Si la confiance n'est pas là, on voit des investisseurs qui hésitent à investir dans un État membre de peur de ne pas bénéficier d'une justice indépendante, au cas où un problème interviendrait avec les partenaires dans un projet économique ou avec les autorités locales. On voit aussi des juridictions, c'est intervenu récemment, je parlais des mandats d'arrêt européens, refuser de délivrer une personne à un autre État membre de peur de voir cette personne se retrouver face à une justice qui n'est pas indépendante. Et ce sont des cas que nous vivons aujourd'hui. Donc c'est vraiment la confiance qui est au cœur de la démarche, mais comme le recteur le disait, l'état de droit guide également l'action extérieure de l'Union, comme le soulignent les traités. L'Union européenne est donc invitée à adopter une approche forte en matière d'état de droit dans son travail avec les pays en voie d'adhésion, les pays voisins, sa politique de développement et plus généralement son action extérieure au niveau bilatéral, régional et multilatéral. Cependant, si l'état de droit n'est pas respecté au sein même de l'Union, comment pouvons-nous être crédibles lorsque nous évoquons nos valeurs avec les pays candidats ou avec nos partenaires internationaux? Plus simplement, pour aller discuter avec les voisins, il est d'abord important de voir ce que l'on fait à la maison. Vous le comprenez, le respect de l'état de droit est essentiel pour le bon fonctionnement de tout l'édifice de l'Union. Un problème d'état de droit dans un État membre est un problème pour tous les autres États membres et pour l'Union européenne dans son ensemble. The increasing interest of the EU institutions in the rule of law results, unfortunately, from the fact that respect for the rule of law cannot be taken for granted, even within the European Union. Over the past years, we have seen rule of law concerns emerging in certain member states. These developments have only made the Commission more convinced of the importance of using all the instruments at our disposal to uphold the rule of law. Over the past years, the Commission has gradually developed and used a rule of law toolbox consisting of a variety of instruments to address these challenges. Notably, in critical situations where judicial independence in a member state is affected, the Commission can, as the guardian of the treaties, launch infringement proceedings against a member state. In Poland, for instance. This has probably been one of the most important recent legal developments in the EU. The basis of the reasoning is that national courts act as EU courts whenever they apply EU law and must provide effective judicial protection as required by Article 91 of the Treaty of the European Union and Article 47 of the EU Charter of Fundamental Rights. In 2018, in its Portuguese judge's judgment, the Court of Justice underlined that the very existence of effective judicial review designed to ensure compliance with EU law is of the essence of the rule of law. According to this judgment, every member state must ensure that in the fields covered by EU law, national courts meet the requirements of effective judicial protection. And the Court of Justice clarified that an essential requirement of effective judicial protection is judicial independence. This was a groundbreaking development for EU law and for the functioning of the Union. Another instrument to react to threats to our values is provided by Article 7 of the Treaty on the European Union. It established a procedure in case of a clear risk of a serious breach of the Union's values, or in the case of the existence of a serious and persistent breach of such values. The deterioration of the situation of the rule of law in Poland led the Commission to initiate the procedure under Article 7 in December 2017. In September 2018, the European Parliament decided to do the same for Hungary. Both Article 7 proceedings are still ongoing before the Council. We have had a state of play at the beginning of the German presidency, and we will have maybe new hearings about Poland and Hungary at the end of the year in the General Affairs Council. These are unprecedented steps in the history of our Union. In recent years, the Commission has also deployed other instruments to protect the rule of law in the Union. This includes measures under the European semester, the annual cycle for aligning economic and fiscal policy in the Union. In this context, the Commission has made several country-specific recommendations on justice reforms in member states, which were subsequently adopted by the Council. This demonstrates the importance of the rule of law for a business and investment-friendly environment. In addition, the Commission submitted a proposal in May 2018 for a regulation on the protection of the Union budget in the event of shortcomings in the rule of law in the member states. If adopted, this legislation would provide the Union with tools to protect its budget if deficiencies in the rule of law undermine or threaten to undermine the financial interests of the Union. The proposal is currently being examined by the European Parliament and the Council and could make an important contribution to the protection of the rule of law and of the Union's budgets. Let me assure you that the Commission is prepared to use all instruments of its rule of law toolbox in order to address violations of our fundamental values in the appropriate manner. And of course, this brings me to the European Rule of Law mechanism, with the Commission's Rule of Law report at its center. It represents an innovative approach, aiming to protect the rule of law in a preventive manner and, of course, to promote it. The mechanism is a yearly process during which we aim to prevent problems from emerging or deepening. It will create joint awareness of the rule of law situation across the EU and keep this topic on the political agenda. It will be a permanent discussion on the rule of law year after year. As from now, the Commission will every year issue a report on the rule of law situation in the Union. The Commission will be providing its own qualitative assessment of general trends and the specific situation in all 27 member states. This unique source of information will enable a better understanding of the rule of law situation in the entire EU. Our report describes recent developments, beginning this year with developments since the beginning of 2019. The report also reflects developments concerning emergency measures adopted during the COVID-19 pandemic. Much of the information as such may not be new to experts, but is now assessed and raised for the first time by the Commission. We are assessing both positive and negative developments, drawing attention to emerging or deepening challenges and highlighting good practices. However, the report is not a formal recommendation. It is rather an important source of information and provides us with clear messages for our monitoring. So we'll continue to monitor on the basis of the different explanations that we have given in the report and the different presentation of good practices or maybe difficult evolutions in different member states. We took care to make a clear difference between punctual concerns that we have in some member states, maybe in all, and more systemic issues that we may see in others. But the comprehensive European rule of law mechanism is more than the report itself. What we want to achieve through this report is a deeper dialogue on the rule of law at the level of the EU and at the national level. By having open debates and by exchanging best practices, we truly want to build a rule of law culture and make EU citizens better aware of what the rule of law actually means for them and how it shapes their life. I'm sure that the disciplinary about the judges in one member state is maybe not immediately a concern for the citizens. But if with such a kind of procedure we are going to a non-independent justice, it must become to be a concern for the citizens. Because if you have a problem in different part of your life and that you need to go to a judge and to justice, you need to be sure that you will have an independent, qualified, and if it's possible, efficient judge in front of you. And that's maybe very important to try to explain to more and more citizens. It's not a theoretical approach. It's very concrete in the daily life of all the citizens, like in the daily lives of the businesses and many other kind of actors in the European Union. And so we try to build such a culture of the rule of law also at the national level. This is why discussions like the one we are having today are so important, and we continue to do that. Maybe one word about the methodology, because I've listened many comments already in some days about the methodology. To set up the mechanism, in January this year, I wrote to all 27 ministers of EU affairs to establish a network of national rule of law contact points in every member state. This was instrumental not only as a constant channel of communication with member states, but also to discuss the methodology of our report. This widely consulted methodology provided the basis for our report. I'm glad to say that on this basis, all 27 member states participated in the process and provided written input. We also carry out a targeted stakeholder consultation where over 200 stakeholders provided written input. These include EU agencies, national and European civil society organizations, and professional associations. And we conduct, due to the pandemic, more than 300 virtual country visits. During these visits, we discuss rule of law developments with member states' national authorities, with judicial and independent authorities, with relevant stakeholders such as journalist associations. Last but not least, every member state had the opportunity to check its draft country chapters for factual accuracy. What was important for us was the close involvement of all member states on an equal footing. We applied the same methodology to all member states and constantly ensure consistency. We made sure that this process was robust, transparent, and as inclusive as possible. And of course, it's all the time possible to improve that for the next reports in the next years. But let me also be clear that this report represents the Commission's own assessment. This takes me to the report itself. We looked at 4 key areas of the rule of law: the independence, quality, and efficiency of justice systems, the anti-corruption framework, media pluralism and media freedom, and other institutional checks and balances. On the independence, quality, and efficiency of justice systems, as a positive development, there are, in a number of member states, efforts underway to strengthen judicial independence and reduce the influence of the executive or legislative powers over the judiciary. The setting up or strengthening of independent national councils for the judiciary is a good example. But it is also true that judicial independence remains an issue of concern in certain member states. For example, as regards the capacity of councils for the judiciary to exercise their functions. We have also more structural concerns over an increasing influence of the executive and legislative branches over the functioning of the justice systems, including constitutional courts and supreme courts. In terms of quality of justice, the current pandemic has highlighted the importance to accelerate the digitalization of justice. It may be the same in education, but in justice is for sure. Many initiatives are ongoing to deliver real improvements. Some justice systems are already equipped with technology to operate remotely. These are good practices to share with other member states, maybe without the same kind of development. I appreciate that several member states have recently adopted comprehensive new anti-corruption strategies or revised existing ones. What will, however, be key is that these strategies are effectively implemented and monitored to ensure that progress is made on the ground. In some member states, measures have been introduced to strengthen institutional capacity to fight corruption and to reduce obstacles to effective prosecution. But our monitoring shows concerns in several member states about the effectiveness of the investigation, prosecution, and adjudication of corruption cases. This includes concerns that high-level corruption cases are not systematically pursued. Thirdly, on media pluralism and media freedom, an encouraging finding of our report was that independence of media authorities is enshrined in law in every member state. That being said, there are worrying signs in some of them with regards to the political influence on the media, a lack of transparency when it comes to media ownership, and risks to journalists and other media actors. We have seen murders of journalists, but we have seen so many other kinds of actions to put pressure on many journalists or media actors in different member states. The fourth and final area of our report are institutional issues linked to checks and balances. On the positive side, there is a healthy debate on strengthening legal and constitutional safeguards in some member states. In a number of them, reform processes are underway. In particular, they concern new channels for citizens to challenge the exercise of executive and legislative power. The advice of international bodies, such as the Venice Commission, can support such processes. The COVID-19 pandemic also provided good examples of functioning checks and balances. Parliamentary scrutiny helped frame emergency response. The measures taken were often reviewed by courts. However, we also identified a number of concerns with regard to checks and balances. In a few member states, we see repeated recourse to expedited legislation in Parliament or emergency ordinances from the government. Moreover, in some member states, civil society lacks an enabling framework, faces a diminishing space to operate, legislation that limits access to foreign funding or smear campaign, to name but a few examples. Now that the report is out, you might ask, where do we go from here? And let me reinforce a point that I have made before. The comprehensive European rule of law mechanism is more than the report itself. The report is a unique exercise, and we need to make the best use of it. What we want to achieve through this report is, once again, a deeper dialogue, and we will try to install a real culture about the rule of law in all the member states. We need such a dialogue at EU and at national level, with the European Parliament, the Council, and national parliaments. National stakeholders will be involved. I'm thinking, of course, of academia and universities. Other examples are judges and journalists, and maybe their associations, and of civil society organizations. We want to promote, again, a rule of law culture across the European Union. And there is a political determination. The German presidency intends to have a rule of law dialogue in the Council based on our report. There will be two discussions in the General Affairs Council, a horizontal discussion covering general rule of law developments on 13 October and next week, and country-specific discussions addressing key developments in specific member states on 22 November, with 5 member states in protocolar order: Belgium, Bulgaria, Czech Republic, Denmark, and Estonia. I'm hoping that it will be possible to continue to do the same with the Portuguese and the Slovenian presidency and the presidencies next year, to be sure that between 2 and 3 years it will be possible to have a peer review on all the member states on the basis of the country-specific chapters that we have in our report, in addition to the communication. I also presented early this week the report to the European Parliament, both in the Libe Committee and in the plenary. And I'm looking forward to continuing my exchanges with this institution. I have proposed to the European Parliament not only to have a general debate, but maybe, again, if I may, to discuss all the country chapters, so to have a real discussion on all the member states and not just about the classical, usual suspects. I'm looking forward, again, I said, to continue this my exchange with the Parliament, and I also have the firm intention to bring the debate to the European capitals. As soon as we can, I will visit physically or virtually national parliaments, stakeholders, and civil societies to discuss the findings of our report, and we will start, I'm sure, with the German Parliament during the German presidency. It's quite logical to do that. And maybe you could all perhaps help me to have this debate or in Brussels or in Warsaw. And so I want to conclude with some words. First of all, the time to debate better and frankly about rule of law has some come. And I'm happy to start this debate here with you all. Let me be clear, our goal has never been to name-shame any countries, but to learn from each other and to give the opportunity to every member state to do better. The Union is built on diversity and inclusiveness. We now have the information on the table, and this information will help us to bring the discussion to a new stage. The Rule of Law report marks maybe a turning point in the European Union, and I'm convinced that the Union will grow from this approach. It must be possible to discuss everywhere in Europe in the same way about our values that we have had discussions, I said, about the budgetary situation. If it's possible to discuss euro by euro the budgets in all the member states, to exchange on the structural reforms, pension schemes, social security systems, and other kind of structural reforms, it must be possible also to discuss about the rule of law. Because I said there are maybe some ideas explaining that it's possible to do everything if you have a majority in the parliament and if you have a government supported by the majority. But it's not true. We have some principles, we have a set of standards, and it's also an obligation for all the authorities to pay attention to those principles and to have a full respect of the standards that we have put into place in our treaties, in the case law of the European Court of Justice, of the European Court for Human Rights. And so there are some limits in the possible actions also organized by a majority or by a government supported by a majority in the parliament. So it's very important to stick to that. And of course, I'm sure that it's very important to discuss on such an issue with, I said, the next generation that you are, because you will be in charge of that. In some years, it will be your role to take care not only of the different budgetary situations in the member states, not only about the structural reform, but also about the values that we are sharing. And the values that we are sharing, it's a very large part of our identity. And that is very important to repeat. If we don't have the capacity to promote and to protect the values, we'll have more and more difficulties to explain that we have a real European identity. Thank you very much.
Thank you very much, Commissioner. Merci Didier, for, I think, a very in-depth analysis and presentation of the report, but also, I think, for a very stimulating introduction to a debate that I'm sure is going to be lively. I'm sure also you've had already the chance to test how lively these debates can be, and I'm sure our students will not be less involved in debating these important issues than others. And I think we're really honored to kick off this dialogue you presented here. If I can just break the ice, we already have one question online, but obviously we'll also collect questions here. And as you rightly mentioned, also our colleagues in Natolin are following. I would like to underline a couple of points that I found particularly interesting and important of what you said, and for sure of the report. One is the attention to the culture and the social dialogue, I would say, about the human rights and rule of law standards. Obviously, the focus is the rule of law, but I think that this is extremely important because it offers the opportunity in all our member states and beyond, possibly, to bring this debate that sometimes is an academic or a specialist one to the societies. And this is so important to bring the necessary consensus then to implement rule of law standards or to make institutions or politicians confident that what they're doing in appliance to the rule of law is supported by the public opinion. So I think that this element of broadening the dialogue and bringing it to the attention of the public opinion is going to be extremely important, and I'm sure the College of Europe is going to be playing its part in any capital, in any way we can do. Because you mentioned rightly so the contribution we can give to this kind of dialogues in Brussels or in Warsaw, but our students are coming from so many different countries within and outside of the European Union. I'm sure they will go back to their own constituencies, because they also have constituencies in academia and in their own cities, and animate this debate in their own countries, possibly. And the second element, and then I'll open the floor to comments and questions from the students, is this attention to have this dialogue and this discussion in all member states of the Union. I think that there's no perfect society, there's no perfect institution, and that rule of law is work in progress. It's true, the European Union is probably the heart of this, but we're not perfect. We're far from perfect. And I think this strengthens so much our not only credibility abroad, but also our credibility within the Union to look at all shortcomings, but also all positive stories, as you mentioned rightly, that we can improve or take as examples. I think there's elements of continuously questioning ourselves about what we can do better, even when apparently there's no problem. Even when there's no problem, there can be improvements and changes brought in the rule of law sector. So I think this is really something that is going to be important. And as you mentioned, the process beyond the report itself, I believe it could be revolutionary in the sense of opening really a new phase in the way in which the Union works on rule of law. So not only thank you, but also congratulations, if I can, for this initiative. And thank you, and a big thank you from our side for offering us the opportunity to debate with you this extremely important report. Maybe I will start from one question in the room and then turn to one question online, and we'll try to alternate things. So I see someone there. We start from up there, then we take one here. And if you can introduce yourself when you ask the question.
Hello, can you hear me? Great.
Yes.
Thank you, Mr. Commissioner. Thank you, Madam Rector. I'm Nicholas. I'm a member of the Queer Europeans, the LGBT plus society here at the college, Student Society. And I'd like to ask you a question on the behalf of the Queer Europeans. And some might argue that the rule of law includes, as you said, justice system, anti-corruption, media pluralism, and checks and balances, but also the respect of fundamental human rights. After all, as you reminded us, all those objectives are mentioned in the Article 2 of the treaty. The Queer Europeans question is the following. What are the very next concrete steps the Commission can take in order to ensure effectively the rights of LGBT plus people in Poland and in the rest of the Union? Thank you.
Take many questions.
If you want, yes, okay.
So if we can take a couple of questions. Let's see if I manage to. How do I show it? Do I do it like this? How do I show the question on screen? I just read it. C'est en français. Le vote des sanctions contre le manquement à l'état de droit se fait à l'unanimité. Or, la Pologne et l'Hongrie poseront toujours leur veto. Comment répondre à cette incapacité à sanctionner? C'est une question qui vient d'un étudiant par... on ne sait pas d'où, mais ça vient d'un des étudiants qui nous suivent de leur... remotely. Well,
but maybe first about the minority rights and the individual rights in general, and human rights and fundamental rights. We have decided to start with a rule of law report. And I will say that my first intention was to dedicate the rule of law report to the independence of the judiciary. Because if you want to be able to say that we are managing in the society by the law, it's very important to show that everybody has a capacity to go to an independent, qualified, and efficient judiciary to ask if the law is in full concordance with the constitutional principles or with the standards, and if the law is correctly applied by the authorities or by other actors. That's the main issue if we are speaking about the rule of law. Of course, we have extended the report to the fight against corruption, to media pluralism, to checks and balances in the discussion with all the member states and the stakeholders. What is possible to do to go further than that? First of all, we have other mechanisms. Next year, we will come with a report on the Charter of Fundamental Rights. So in the same way there, we will have an analysis of all the different individual rights. It's another kind of process. We'll have also a democracy action plan about the democracy. And of course, it will be possible to make some remarks on the situation in all the member states. So I've said to the Parliament, why not maybe next year, to put all those reports together and to have one debate. But we have a first document on the rule of law as such, and we have said for the fundamental rights, it will be another discussion in the report on the Charter of Fundamental Rights. And what is possible to do? But sometimes it's possible to use other instruments to launch infringement proceedings. If there is a link between a specific situation and the EU law, because you know that to go to the courts, of course, we need to have the capacity to prove that there is a link with the EU law, or to take some actions. To give an example about the funding of some policies, it was possible for one European agency to stop the funding of some twinnings between municipalities in Poland and municipalities outside Poland due to the fact that those municipalities in Poland have decided to organize LGBTI plus free zones, so-called free zones. And so, of course, it's a discrimination to the Charter. So again, it's an additional tool. That doesn't mean that we don't have other tools to make the same kind of approach about the individual rights and the minority rights. It will be the report on the Charter, and that it's possible to use all the instruments at our disposal to try to help the different minorities in all the member states and to try to come with action plan. Yesterday, we have adopted a new plan about the Roma situation. It's another kind of minority in Europe. And of course, we try to use all the different tools to do that. Concernant le vote, je dirais que le vote à l'unanimité, d'abord, on le sait même en politique extérieure de l'Union, c'est un des débats les plus compliqués de savoir selon quelles règles de procédure on peut prendre une décision. Parce que de nouveau, on est dans une logique de confiance. Si l'on ne dégage pas une confiance très forte entre les États membres, on en reste à l'unanimité. Si on dégage une confiance plus importante, on peut accepter d'être de temps en temps dans la minorité, mais tout en se disant la décision est quand même une décision européenne, comme on peut accepter parfois dans un Parlement national d'être mis en minorité et de voir une décision quand même devenir la loi ou devenir la règle dans le pays. Alors, au niveau européen, ça a pris du temps. On est passé de l'unanimité à la majorité qualifiée dans un certain nombre de domaines. On en parle beaucoup maintenant de cet usage possible, parce que les traités le permettent, de la majorité qualifiée pour des dossiers internationaux. Je ne vais pas revenir sur les débats tout à fait récents sur le Bélarus, mais comment arriver à se défaire de la règle de l'unanimité? C'est un choix des États de dire non, nous continuons à travailler au consensus ou à l'unanimité plutôt que cela. En politique macroéconomique, on a accepté d'aller même un peu plus loin, d'utiliser ce qu'on appelle la majorité qualifiée renversée ou inversée, c'est-à-dire non pas demander à la Commission, quand elle fait une recommandation, d'obtenir la majorité qualifiée du Conseil, mais plutôt de dire que si l'on veut changer la recommandation de la Commission, il faut dégager une majorité qualifiée au Conseil contre l'avis de la Commission. Alors quand on parle des valeurs, on est évidemment au cœur du débat sur la confiance, et c'est vrai que c'est très difficile d'obtenir des décisions à l'unanimité, voire à la majorité qualifiée, notamment dans le cadre de l'article 7 du traité. D'où le débat actuel sur la conditionnalité des financements du cadre financier pluriannuel et de ce qu'on a appelé Next Generation EU, les 750 milliards d'euros complémentaires qui sont demandés dans le cadre des plans de relance, la liaison entre ces éléments et l'état de droit. Et le débat porte sur beaucoup de sujets, le champ d'application, mais notamment sur le type de majorité requise. La Commission, en 2018, je l'ai rappelé tout à l'heure, a déposé une proposition avec une proposition de majorité qualifiée inversée de nouveau. Le Conseil est plutôt d'avis d'aller vers une majorité qualifiée. Il y aura donc un débat entre les co-législateurs, le Parlement, qui soutient aussi la majorité qualifiée inversée, et le Conseil. Mais je ne veux pas terminer sur les règles sans rappeler qu'il y a d'autres procédures, évidemment. Si l'on n'a pas la capacité de prendre une décision au Conseil sur ces sujets, la Commission a toujours la possibilité, si elle estime qu'il y a une violation des règles européennes, d'aller devant la Cour de justice, ce qui est l'élément principal. Et nous avons obtenu, on pourra y revenir si vous le souhaitez, un certain nombre de décisions de la Cour de justice sur des violations de l'état de droit, des violations du droit européen, encore récemment en Hongrie, en ce qui concerne les financements dans le secteur de l'éducation, notamment de l'enseignement supérieur, par des fonds venant de l'extérieur du pays. La Cour s'est opposée à la réglementation mise en place en Hongrie. Donc il y a d'autres outils, mais les règles de majorité, il faut que les États membres acceptent évidemment de les faire évoluer. C'est un travail particulièrement complexe, parce que c'est d'une certaine façon un abandon de souveraineté, de ne pas disposer de l'unanimité, et c'est une confiance à faire dans les institutions et dans les autres États membres lorsqu'on décide de voter à la majorité. Mais on le fait dans les parlements, on le fait même à la Commission, pourquoi pas avoir cette évolution de plus en plus au Conseil.
Thank you very much for the answers. I like normally to talk about sharing sovereignty rather than ceding sovereignty. I think this is, but it's true. It's going to be probably an interinstitutional fight. It might be interesting one day to organize, maybe with Commissioner Reinders or with others, a discussion about the use of qualified majority voting in the institutions in other fields. I would be very much interested in this. But this is not the place for that, but thank you for answering the questions. I will take maybe 3 questions now.
Okay.
One, and then, yes, we move here. Please.
Bonjour à tous. Merci beaucoup, commissaire, pour cette intervention. J'aurais une question concernant l'impact supplémentaire de cette forme de dialogue par rapport aux formes qui existent déjà. Donc, je pense notamment à l'article 7.1 ou alors le cadre sur l'état de droit de la Commission. Donc, on a vu à travers ces autres formes de dialogue que ça ne changeait pas forcément la situation pour les États dans lesquels on voit de plus en plus de menaces par rapport à l'état de droit. Donc, je voulais savoir dans quelle mesure ce nouveau dialogue apportera quelque chose de plus, puisque j'ai plutôt confiance en votre proposition, en la proposition de la Commission, concernant la conditionnalité des financements par rapport au respect de l'état de droit. Merci.
Merci beaucoup. Je prends peut-être une autre question ici, derrière, et après une de web, pas de web, d'un autre étudiant.
So, Mr. Commissioner, first I would like to thank you for sharing with us your comments about the rule of the report only a few days after its publication. And I had 2 questions, but you
Sorry,
already...
I forgot to ask also the previous students to present yourself. Sorry.
Yes, so my name is Alexandra. I was a student of the college last year, and I had the opportunity to work on the rule of law during my thesis. So my question is that the rule of law mechanism seems to favor dialogue, but don't you think that in certain cases the time for dialogue is over? I'm thinking, for example, about Poland and Hungary, and shouldn't we strengthen and accelerate the launching of infringement proceedings before it's too late, maybe by considering explicitly basing these procedures on Article 2 TEU?
Thank you. And then I will read another question that one of the students that is following us remotely is asking. European arrest warrants can be challenging when a country is not respecting the rule of law, but can sometimes be a way for a member state to freely challenge the state of the rule of law on another member state or other member states.
Okay. D'abord, la valeur ajoutée du rapport, en fait, c'est bien une valeur ajoutée. Donc, je dis cela parce qu'il s'agit bien d'un instrument supplémentaire. Il ne va remplacer aucun des instruments existants. La Commission va continuer à utiliser tous les autres instruments à sa disposition. Donc, il ne s'agit pas d'abandonner ni l'article 7 du traité, ni les procédures d'infraction, ni tout autre mécanisme existant. Et on souhaite même en ajouter un autre, vous l'avez rappelé vous-même, la conditionnalité en matière de financement d'un certain nombre de politiques, la conditionnalité à l'égard de l'état de droit. Alors, quelle est la valeur ajoutée? D'abord, c'est la première fois que l'on présente une photo, finalement, de la situation dans les 27 États membres. Et donc, il ne faudrait pas que parce qu'il y a une attention particulière qui se porte sur l'un ou l'autre État, ailleurs, on soit convaincu que tout va bien, qu'il n'y a absolument aucune préoccupation en matière d'état de droit. Donc, nous souhaitons vraiment avoir une amélioration du dialogue permanent avec les États membres. Mais c'est le deuxième aspect, c'est pas seulement les 27, c'est à tout moment, puisqu'il y aura un rapport annuel, et donc nous allons dès le début de l'année prochaine commencer le travail sur le deuxième, et ça se poursuivra. Il y aura une discussion entre les pairs au Conseil sur tous les États membres, et ça va se faire dès lors semestre après semestre. Donc ça devient une préoccupation permanente à l'égard de l'ensemble des États membres. Et c'est vrai que l'élément fondamental au-delà de tout cela, c'est d'avoir ce que j'ai appelé ce dialogue, cette culture de l'état de droit dans les États membres, pas seulement entre institutions européennes. Et là, c'est le travail qui sera le plus compliqué, probablement parfois, le plus long à mettre en place, c'est d'aller dans les parlements nationaux, où on ne rencontre pas seulement les majorités, mais aussi les oppositions. d'aller dans les différents États membres à la rencontre de tous les partenaires de la société civile, qui peuvent avoir aussi un autre avis, et tenter de faire en sorte que le débat sur les valeurs, sur l'état de droit, s'installe progressivement dans la société. C'est un travail de longue haleine, c'est le but de ce dossier. Mais pour vous donner simplement une anecdote, je me souviens d'avoir siégé pour la première fois au Conseil ECOFIN en juillet 1999, comme on dit en Belgique, ou 99 s'il y a des Français dans la salle, et le débat portait sur la situation budgétaire et consistait à féliciter tous les États et un peu plus certains. La crise bancaire, la crise des dettes souveraines ont fait que l'on a renforcé les règles, on a créé le semestre européen, on a organisé des recommandations et on est devenu même apte à discuter de sanctions éventuelles dans le cadre des budgets. Je pense que sur l'état de droit, il est urgent d'avancer dans le débat, mais tout ne va pas se faire en une nuit ou en 2 jours, d'où l'idée de ce rapport, je le répète, dont la valeur ajoutée est vraiment celle-là, d'être un document permanent sur les 27 États membres. And so, is it possible to install a dialogue in Hungary and in Poland? I hope so. And I've said I'm very open to go to the national parliament, also in Warsaw and in Budapest, and I'm very open to discuss with civil society. It was already the case before. I've organized that before in the capitals as a member of a government, but I'm very open to do that as a member of the Commission. And again, we are not sure, and we are not saying that we will solve the situation in those countries with the report only. Again, it's an additional instrument. Why? Because in the report you will read some reference to the Article 7 procedure. So what is important, I've said that in my introductory remarks, we make the difference between punctual problems and concerns about the rule of law in all the member states and systemic problems that we have. And what is possible to do? The most efficient way, maybe, is to go to the Court of Justice. And we are doing that, because if we have so many discussions about different kind of infringement proceedings, it's due to the fact that the Commission decided to do that. And we have received positive answers from the Court of Justice in different fields. And we continue. I know that there are many discussions about the so-called muzzle law in Poland. But we have started a procedure. And so if there are discussions, it's because we have started a procedure. And we will continue to go in such a procedure. We'll take some decisions in the next weeks on this. The same about the disciplinary for the judges, because sometimes we go to the court for general problems and general concern about the law. But sometimes there are some direct consequences for the individuals. You remember maybe at the beginning of this year, we have received in Brussels, but also in many other places, many associations of judges, some judges themselves coming and explaining that they have huge problems with disciplinary proceedings in Poland due to the fact sometimes that it's just a procedure on the basis that they have tried to ask some questions to the European Court of Justice. So they've tried to apply the EU law. And it was a huge debate. What was possible to do? I have asked to the Commission in February to go to the court for interim measures. And we have received an answer 2 months later, not so long, 2 months later, in April, to suspend all the disciplinary procedures about the judges in Poland. And of course, if it's possible to see that it's not applied, we are very fine. I've sent a new letter to the Minister of Justice in Poland. We'll see if it's needed to go back to the court. So we are continuing to do that. But certainly before the students, because you are, for the moment, using more and more the videos and the remote systems, and you are certainly very present on the social media, I see many reactions, sometimes from professors. I don't speak from this college, of course, from others, but saying you need to do more. You need to go today to the court and tomorrow a decision. We don't have the same timeline than Twitter. If we want to go to the court, we need to have a robust argumentation, and we need to not to be sure, but to have a certain level of certainty that we will receive a positive reaction from the court. And of course, before the court, it's quite long. If it's not with an exceptional procedure like the interim measures, it's quite long, maybe 2 or 3 years before to receive a decision. But of course, if we are speaking about the rule of law, it's quite logical that in a procedure before the court, it's possible for the member state to present their arguments, to exchange in a normal way, and then to the court to take a decision. But I know that I've received so many tweets asking to do something in the same day that it's possible to see the vote of the law. But I repeat, and Federica know that, and the rector know that, when we start a procedure, we send a letter, a formal notice to the member state, then we give time to the member state to reply, and on the basis of the reply, we need to see if it's needed to go to the court. And sometimes, just in the dialogue, we have a correct reaction. It's true in many cases. And so it's the reason why it's not with the dialogue that we'll solve that. We will continue to use other instruments. And it's possible to have an appreciation of the rule of law in many different places. And of course, about the open arrest warrant, it was the question. For the judges, it's also possible to do that. I gave the example of courts refusing to surrender some people to another country. To be very concrete, we have seen the case in a court in Amsterdam refusing to surrender people to Poland. And of course, I've read till now in the press, I've asked to receive more information about the content. There is also a decision in Warsaw refusing to surrender people to Netherlands due to a lack of independence of the justice system in the Netherlands. So what that means? That means that, of course, it's not just an appreciation for the open institutions. It becomes to be a real problem of trust and confidence between the different actors in the society. We have received also some remarks from investors saying we are afraid to invest in some member states because we are not sure that we'll have an independent justice. The same for the judges. And sometimes, I must say, on the basis of very factual evaluation, to give an example, to surrender one people to another country, you need to be sure not only to have an independent justice, but maybe to have correct detention conditions. And to be sure that it's possible to have an evaluation about the situation in the prisons, we have provided to the judges an instrument. There is a data bank in the Fundamental Rights Agency explaining the situation in all the prisons. And there also, it's not just to give an information to the judges, but also to push pressure on the member states to have a better situation in the prisons, because that is more maybe in line with the fundamental rights. It was mentioned at the beginning in the questions, than with the rule of law as such. But it's true that the evaluation of the rule of law, it's a problem, it's a concern not only for the institution, for many other actors in the entire European Union.
Thank you. I will take one question there in the back, one here in front. You also raised your, it was already answered, very good. And then we have another two questions on the web. And let me also use this time to thank the academic assistants that are helping us with the logistics and not only with setting up the entire conference. Thank you.
Hello. Thank you very much for being here today with us. My name is Anastasia. I'm from Ukraine.
Can you speak up a little bit?
My name is Anastasia. I'm from Ukraine. And it is stated in the report that the fight against corruption cannot be reduced to a standard one-size-fits-all set of measures. So I have a question concerning this matter. How do you think, to which extent are the factors of mentality and cultural differences crucial for the understanding of the reasons of corruption existence in European countries and in other countries in general? Thank you.
Thank you. How do you...
Maybe if you have better understanding.
If I got it right, how do you think cultural differences and also, I guess, historical backgrounds can change the approach to rule of law, standards and implementation? You mentioned the fact that there's no one-size-fits-all, and how can this be tackled?
Yeah, and also like the legal mentality, like the understanding of law by the society.
Thank you. I apologize for that, but the combination of mask, microphone, I mean, it's, we are adapting to this new way of doing things. And thank you all for the flexibility. I think we have one question here.
Bonjour, Monsieur Reynders. Merci beaucoup pour votre discours. Je m'appelle Alix, je suis étudiante en droit et je suis aussi belge. J'ai une question pour vous par rapport au respect de l'état de droit au sein de l'Union même, donc au sein des institutions même. Parce que ce rapport, il parle que de la situation dans les États membres, mais il ne parle pas de la situation au sein de l'Union européenne même. Et pour donner un exemple concret, c'est déjà depuis Lisbonne que ça a été inscrit dans les traités que l'Union européenne allait adhérer à la Convention des droits de l'homme, la Convention européenne des droits de l'homme, mais ça n'a toujours pas été le cas. Et donc, je me demande comment la Commission, compte faire quelque chose à ça, ou comment la Commission compte évaluer sa propre situation et la situation au sein des institutions. Merci.
Merci beaucoup. I'm now going to read maybe one, or if I manage, even two questions we received online. Good morning, Commissioner. Good morning.
Good morning.
Would you please tell us more about the concrete engagement of the Union on this topic when it comes to its external action? And it was not me asking the question, but I'm very interested in that, and maybe I can comment on. And then another one. Thank you, Commissioner. Welcome from Natolin. So we have a question from one of our students in Natolin. Good to have you connected. Would you give us an opinion concerning the accession to the ECHR and on how this could help in assuring the respect of rule of law within the bloc?
Some different kind of questions. Of course, we have different kind of background, and it's possible to see a difference in the culture in different parts of Europe, and not only, like we have said sometimes, between the west and the eastern part of Europe. There are more differences than that. If you are coming from the Scandinavian countries to Italy or to the south of Italy or to Portugal, we don't have exactly the same way to think about different elements. But it's true that we have different background. But it's a reason why we have put at the beginning of the report the references about the rule of law. What are the standards? And all the member states agreed on the treaties, because it was a decision to take part in the process. And so the Article 2 is very clear about different kind of principles. And then we have put the reference to what? The case law from the European Court of Justice, from the European Court for Human Rights, but also some decisions from the Council of Europe, and in the Council of Europe, maybe the Committee of Ministers, with more people and more member states of the Council of Europe, you know that, than the European Union. So also with maybe some other kind of background. And so we don't ask to have exactly the same appreciations. To give an example, the family law, it's a national competence for a very, very large part. We have very few elements at the EU level. But, of course, you have different kind of conceptions about the family in different member states. But we have some principles, and I'm saying that to take one example, the Istanbul Convention. Maybe it's possible for some member states, and we have seen that also in the EU, to say, no, we don't want to ratify because we don't have the same definition of the gender or the same definition of the family. I don't want to elaborate on that. I'm sure that it's not true, but it's so. They doesn't want to ratify. There are some member states. But the violence, the domestic violence against the women and the children, it's a crime. It's not a question of culture. It's a crime. And so if you don't ratify the Istanbul Convention, we'll need maybe to come with an EU instrument, at least to fight against the domestic violence, because it's not true that it's a developed culture. Everywhere in Europe, it's a crime to come with such a kind of violence. So it's a mixed answer. Of course, there are differences, because all is not in the EU law. You have many competence at the national level, with some room for maneuver in different sectors, and certainly in some very sensitive issues. When you think about the civil law or the criminal law, we have different kind of tariffs in the criminal law and so on. So the culture is very present, but not when we are discussing some standards. And we have explained that in the report. So we are not putting criticism on all the different differences that we have in the Union. It's just about the differences in contradiction with the standards that we have to define the rule of law and other kind of principles. Dans les institutions européennes, et c'est un peu la même question qui revenait sur la Convention européenne des droits de l'homme, c'est vrai qu'on pourrait ajouter un 28e chapitre sur les institutions elles-mêmes, puisqu'on fait le travail sur les 27 États membres. Ce n'est pas ce qui a été prévu dans la communication de 2019, mais c'est vrai qu'une des solutions qui a été évoquée et qui se trouve dans le traité de Lisbonne, c'est en matière de droits de l'homme, d'adhérer à la Convention européenne des droits de l'homme. Moi, je suis un fervent partisan de cette adhésion. Dans d'autres fonctions et dans d'autres cadres, j'ai tenté de rencontrer les présidents, notamment des 2 cours de justice. Mais nous avons aussi une Cour de justice de l'Union européenne. Et la Cour de justice a émis un certain nombre de remarques que la Commission avait commencé à examiner. Je pense que c'est tout à fait possible de résoudre les points qui ont été soulevés. Donc c'est une question maintenant de volonté politique d'avancer. Donc nous avons prévu de relancer les négociations avec le Conseil de l'Europe et de faire en sorte qu'on puisse effectivement progresser vers une adhésion de l'Union européenne. Parce qu'à nouveau, ça n'a pas beaucoup de sens de demander aux États membres, je l'ai rappelé tout à l'heure, de respecter les recommandations de la Commission de Venise, d'intégrer, comme nous l'avons fait dans le rapport, les remarques du Greco en matière de lutte contre la corruption, et puis de dire, mais nous avons nos règles spécifiques. Ça n'empêchera jamais l'Union européenne d'aller plus loin si elle le souhaite, comme les États membres peuvent aller plus loin que ce que prévoit la Convention ou que ce que prévoit le Conseil de l'Europe. Mais c'est un peu la démarche. And so it's the same answers about the adhesion and accession to the Convention. I'm sure that we need, that will be the case, to restart the negotiations, and we need to be proud about such a decision to take part in the process also in Strasbourg for other reasons, the other Strasbourg about the Human Rights Convention. About the external action, I said, first of all, to do that, it's very important to do the job at home. And I'm saying that because in the last years, I've had the feeling and I received the reactions from many actors in the world saying, yes, but you have a sort of problem. To give an example, you discuss about human rights with one of another partners in the world, and you receive the remarks, yes, but in the Mediterranean Sea, you have so many dead people, so many migrants coming from Africa, from Libya, first of all, and you have so many dead people in the sea, and what is the situation? And so we need, on all the different situations, to try to show that we are doing the job at home. It's maybe why also we were coming some weeks ago with a new pact on migration to try to see how it's possible to give an answer to such an issue, because we have a real issue about the migrants around Europe. And in the external action, it's very important. We have adopted in February, a new methodology about the accession and for the candidates. And yesterday, we have organized the process about the new use of this methodology. And of course, in the methodology, the rule of law is at the beginning of the process and at the end. And we want to be sure that it will be possible for the candidates to fulfill all the criteria, also the political criteria in relation with the rule of law, before to be a member. And so we have given assessment, like in our report, on all the different candidates in the enlargement package yesterday. When we discuss with the partners, the Eastern Partnership to be concrete, we have received in the last days the Prime Minister of Georgia in Brussels, but also now we are preparing a summit with Ukraine, and in March, not fixed, but maybe in March next year, we'll have a new summit between the European Union and Eastern partners. But there also, we need to show what are the progress or not in the different reforms in those countries to try to fulfill the same criteria. And all those countries in general are in the candidates, the partners, are also members of the Council of Europe in general. So it's quite possible to do that. And of course, when we discuss with Africa, we have started a new partnership with Africa. We have put on the table not only the discussions about the human rights for individuals, it's very important, of course, to pay attention to the situation of individuals in the countries, but so more about the rule of law. What kind, again, of independence of the justice systems, what kind of fight against corruption, what kind of media pluralism and check and balances. And we have had at the beginning of this year, it was started before, but we have started again a discussion with the African Commission, so between the European Commission and the African Commission, and I have asked to put in all relations the same kind of approach about the rule of law. And they agreed to do that, because of course it's needed to see what are the possible positive evolutions or negative evolutions about the same issue. So it's a real part of the external action But again, if we want to be credible in all external action, speaking about the rule of law, the fundamental rights, and other issues, we need to do the job in the EU. We need to do the job at home. And that is very important before not before, but again, to be credible out of the European Union. And sometimes we are alone, to be concrete. When we discuss with the candidate countries in the Western Balkans, we are coming with investment plans, but we are also coming with some requests on reforms to fulfill the same criteria about the rule of law and the fundamental rights and the democracy. I'm not sure, I don't want to mention 2 or 3 other international partners, but I'm not sure that all the countries having such a presence in the Western Balkans have the same idea to make a link between their investment, their presence in different fields, and the necessity to apply the same rules about the rule of law and the fundamental rights and the democracy. But I don't want to mention 2 or 3 other partners than the European Union in the Western Balkans.
Thank you. Well, maybe they promote their own rule of law standards. I'm now more free than you to say so. But if I can add a comment on this external part of the work, I think this report can really represent a turning point in the European Union engagement with third countries on rule of law, not only on human rights, as you rightly said. In my own experience, and that coincided with the times when you were foreign minister, so we've seen these developments in parallel. Many times the European Union was trying to establish rule of law and human rights dialogues with partners, difficult partners with whom normally rule of law and human rights dialogues were not the first point on the agenda for them, let's put it this way. And sometimes we managed to establish them simply because we accepted not to have a dialogue on their rule of law and human rights situation, but a dialogue on the respective situation on rule of law and human rights in this partner country and the European Union. So I think that this approach of looking inside of the Union and how standards can be fulfilled or even improved, I think it's going to be a very important point in the credibility and also in the openness of the approach of the Union towards third countries. And I would like to underline another point on the external impact of this. The very important point the Commissioner underlined several times about the economic impact of the rule of law standards. In many countries, especially I think of some Asian countries or some sub-Saharan African countries, the European private investment comes only when there are rule of law standards that guarantee to them that their investments can then be protected by a fair system of rule of law institutions. And once the institutions on these partner countries get this economic impact of the rule of law standards, then the entire story changes. And there is a lot more of interest in trying to have a common work on guaranteeing, especially the certainty of the judiciary system and the certainty of the law in some of the countries. I'll see if there are other questions in the room. 1 here and 2 there.
Bonjour commissaire Reynderds. Tout d'abord, merci beaucoup pour votre discours ce matin, très intéressant. Je suis belge aussi, donc je m'appelle Timothée Curemans et je suis en études politiques ici. Et ma question est par rapport à la Belgique, en fait. Je voulais avoir votre avis sur la façon dont la crise du Covid avait été gérée au niveau belge, surtout avec les différents niveaux de pouvoir. On a eu beaucoup de définitions différentes au niveau des réglementations qui ont diminué très fortement la sécurité juridique au sein du pays. Et puis il y avait aussi la question des pouvoirs spéciaux qui ont été attribués au gouvernement, la façon dont ils avaient été formulés. Et de la même façon, j'avais également une question sur les définitions différentes qui avaient été données au sein de l'Union européenne par rapport aux partenaires et qui avaient justement mené à aussi une diminution de la sécurité juridique par la fermeture des frontières. Merci beaucoup.
Merci beaucoup. J'ai l'impression que tout le monde ici a une opinion sur la gestion belge de la Covid. Maintenant, on a 2 questions là.
Yes, it's me. Okay.
Yes.
Good morning, Commissioner and Director. You mentioned that we need to educate the societies in order to make them aware of how important is the rule of law. So do you have any particular ideas? Because it's very difficult, I would say, to actually go deep down to the societies and make them aware that rule of law is actually the thing which really impacts their daily basis life. Because, well, what now we see in different countries, it's the government, like they do different things, but they were like chosen. So this is probably the lack of course, the knowledge of the societies, but how to like repair it.
Thank you. There, yes. If you can introduce yourself. Oh, that's a
Hello
more and more
everyone.
challenging for our assistants.
Merci, monsieur le commissaire, et merci, madame la rectrice. Du coup, je m'appelle Théo et je suis un étudiant dans le département d'études politiques. Et ma question, c'était surtout, comme vous l'avez mentionné, depuis Lisbonne, les valeurs sont quand même très clairement mentionnées. Les États sont tous d'accord sur celle-ci. On a également la Charte des droits fondamentaux de l'Union européenne, donc qui est censée garantir ces droits. Et comment, parce que là, on parle de l'état de droit à l'heure actuelle, mais comment expliquez-vous que on a l'impression quand même qu'on a une dégradation et que ça s'enracine, alors qu'on a quand même un droit supranational qui est censé être préventif. Et est-ce que, c'est peut-être un petit peu pas dur de dire ça, mais est-ce que la Commission n'a pas échoué en tant que gardienne des traités par rapport à l'état de droit? Merci.
Merci. Nous n'avons pas de questions en ligne pour l'instant, donc je pense que
peut-être d'abord, concernant les différents États membres, je disais, tous les États membres sont dans le rapport et sont logés à la même enseigne. Ils sont traités sur un pied d'égalité, en ce compris les mesures prises pendant la période de l'état d'urgence ou de l'état de danger ou de crise sanitaire ou de pouvoirs spéciaux. On a eu pas mal de noms différents. Il y a plus d'une vingtaine d'États membres qui ont pris des dispositions. Alors, qu'est-ce que l'on a observé? C'est d'abord dans les équilibres entre les pouvoirs de dire il est assez normal que dans des périodes de crise sanitaire aussi fortes, il y ait un glissement de compétences ou de capacité d'action des parlements vers les gouvernements pour des raisons d'urgence. Et donc, déjà, quand j'avais demandé tout au début de la crise que l'on fasse un monitoring avec la Direction générale de justice de toutes les décisions prises, la première remarque que nous faisions, c'était évidemment d'admettre qu'il était tout à fait logique que un grand nombre d'États prennent ce genre de mesures. Alors, pour la Belgique comme pour d'autres, ce que nous avons dit, il faut que dans les mécanismes mis en place, il y ait une limite dans le temps. Première chose. C'est pour ça qu'il y avait une préoccupation forte sur la Hongrie et pas nécessairement sur d'autres États membres, parce que nous ne voyions pas, dans le cas hongrois, quelles étaient les capacités de sortir, si ce n'est par le gouvernement lui-même. Bon, le gouvernement hongrois a mis fin à l'état de danger, donc d'une certaine façon, on a réglé le problème, même si vous verrez dans le rapport qu'il y a toujours des préoccupations sur le fait qu'on est passé dans une autre situation de crise, d'état d'urgence sanitaire et que des mesures continuent à être appliquées. Mais dans le cas de la Belgique, comme dans d'autres, mais dans le cas de la Belgique en particulier, ce que l'on regarde, c'est dans les équilibres, si, au-delà de la limitation dans le temps, il y a des contrôles possibles. Donc si le Parlement continue à jouer son rôle de contrôle et si les juridictions jouent leur rôle de contrôle. Je ne prononcerai évidemment pas, vous en doutez, sur les mesures de santé publique prises, mais s'il y a des doutes sur ces mesures de santé publique, il doit être possible, dans l'ordre d'équilibre des pouvoirs, d'en débattre au Parlement et de revenir éventuellement sur ces mesures, mais aussi d'en débattre devant des cours et tribunaux. Et nous avons vu, dans un certain nombre d'États membres, que c'était tout à fait possible de mettre en cause soit la constitutionnalité d'un certain nombre de dispositions prises, soit les conséquences et de demander des dommages et intérêts, notamment dans le cadre de décisions prises. Et vous savez qu'en Europe, en Belgique comme ailleurs, il y a énormément de procédures introduites maintenant devant les cours et tribunaux contre un certain nombre de décisions ou d'orientations prises par les autorités publiques. Mais ça me permet aussi de dire un mot sur la problématique que nous avons vécue au début de la crise. Vous avez souvent entendu cette question, mais qu'on entend dans beaucoup de domaines, que fait l'Europe? La politique de santé est une politique avant tout nationale. Donc nous avons tenté de coordonner les choses. Et dans le portefeuille qui qui m'a été dévolue, et notamment la libre circulation. Et avec des collègues, on a tout fait pour que les frontières ne soient pas complètement fermées. Parce qu'on a tout de suite pensé aux fermetures de frontières pour les personnes. Mais imaginez qu'au début de la crise, certaines frontières étaient fermées et on ne pouvait dès lors pas, par exemple, transporter des masques ou d'autres équipements de protection ou de soins d'un pays à l'autre. On a donc installé des green lines, des lignes vertes pour passer malgré tout les frontières. Et petit à petit, on a essayé d'équilibrer. Alors, je vais vous donner un exemple qui peut paraître simple, mais le dernier Conseil européen a heureusement, dans ses conclusions, mis en premier point une demande de coordination. Nous avons adressé début août une lettre aux États membres pour demander de coordonner la situation en matière de libre circulation. Le début septembre, on a adopté en commission, le 4, je crois, une proposition de recommandation du Conseil qui doit être adoptée par le Conseil pour fixer des règles communes. Et nous espérons maintenant que peut-être au prochain Conseil Affaires Générales, la semaine prochaine, il y aura une évolution sur le fond. Mais pour vous dire concrètement, que demande-t-on? Et voilà un exemple de ce que la Commission peut tenter de faire en demandant aux États membres de la suivre. Est-ce qu'on ne peut pas avoir les mêmes critères pour définir les couleurs des zones partout en Europe? Dire à partir de quel taux de tests positifs sur un volume de population ou sur le nombre de tests effectués, une zone est-elle en rouge, en orange ou en vert? Est-ce qu'il n'est pas possible que la carte soit la même pour toute l'Europe? Si un pays, une région est en rouge, mais que ce soit pour tout le monde. Donc il y a capacité au niveau européen, avec le Centre européen qui est spécialisé en la matière, de le faire. Et puis, est-ce qu'il n'est pas possible que le changement de carte se fasse une fois par semaine, avec quelques jours, 2, 3 jours, on peut discuter de délai pour la mise en œuvre. Les mesures, on essaie d'éviter qu'on ferme les frontières, mais les mesures, ça peut être des tests, évidemment, et ça peut être éventuellement des mesures aussi de quarantaine. Mais même ces mesures-là de base, mais comme elles ne relèvent pas directement de la compétence européenne, il faut convaincre les États, et je peux comprendre qu'en matière de sécurité publique ou de santé publique, les États sont très soucieux d'avoir leur propre dispositif et leur propre mécanisme. Mais on se rend bien compte qu'un minimum de coordination est indispensable. Alors voilà, y compris à l'égard du pays que vous avez cité, de la Belgique, c'est une des démarches que l'on essaye d'entreprendre. Mais c'est surtout le contrôle que l'on a voulu vérifier. Et il existe sur des pouvoirs spéciaux, sur beaucoup de législations d'urgence dans des pays européens. About the dialogue, it's not... First of all, to organize an education of the population. It's first of all to try to install, I said, a culture, a dialogue, but it's true that it's also needed to work maybe with some attention to the education system. And we will be maybe open, I'm coming here, but I'm sure that it will be very important to see if it's possible some programs in the schools, in the university, but not only at the high level, but maybe in the secondary schools, to give more information about the values and to try to explain what is it in the daily life. I said an independent judge, it's maybe important to explain why it's so important if you have any kind of problem to have a real independent judge in front of you. And it will be maybe important to discuss about that also in the educational system. But we are doing more than that. Of course, we want to go to the national parliaments, to the different stakeholders, the NGOs and the civil society in the different member states, but we finance also from the EU level different NGOs, different kind of associations of human rights defenders, or association to protect some minorities and so on. So it's very important to build such a relation with the different actors, and I'm sure that it's a part of the different actions that we have the capacity to take. But at the end, it will be a long process. To give an example, in the report you will see that about the independence of the judiciary, since the beginning of this year, we have quite a positive evolution in Malta, with some reforms, with real discussions between the Maltese authorities and the Venice Commission, and the possibility to see different change in the law. Of course, we will verify the implementation and the fact that it will be effective. But it's due to what? Maybe the pressure from the European institutions, but maybe also a real shock in the society due to the murder of a journalist, an investigative journalist, Daphne Caruana Galizia. And after that, we have seen some turbulences also at the political level with the new government, but then a real change in the civil society. Of course, unfortunately, it was after such a murder. But if you don't have a real change in the local and national society, if you don't have a real debate about the rule of law in the society, it's become to be difficult to have an evolution. So it will be, I don't want to say a long process, but it will be a process month after month and maybe year after year to do that and to try to install. But education, it's a part of the process. Action with different kind of stakeholders at the national level also. But we need to go to the member states and not just to discuss the report of the Commission in the European Parliament and the European Council. We need to go on the ground in the different member states. And of course, we will try to install. If you look back some 15 years or 20 years ago, I said discussing about the budget, it was not so evident in some member states. And now it's become to be the rule. Discussing about the structural reforms, the same, but it's become to be the rule. Maybe we'll have the same process, but I'm hoping in a short period of time, about the values. Et sur la dégradation, d'abord, je pense que la dégradation est réelle en matière d'état de droit dans un certain nombre de domaines. On le dit d'ailleurs dans le rapport en ce qui concerne la liberté de presse. Il y a un recul qui n'est pas seulement lié à des attaques contre des journalistes, à un poids plus fort du politique, qui est lié aussi à la situation économique du secteur de la presse, avec l'arrivée des plateformes, avec l'arrivée des médias sociaux. On a vu un changement complet et une difficulté de maintenir la viabilité d'un certain nombre d'organes de presse. Donc on doit aider à investir dans le digital, aider à investir dans de nouvelles technologies, mais on doit le faire en respectant le pluralisme. Et là, on a un rôle à jouer. Je prends l'exemple de l'investissement pendant la période de crise. Il y a des aides d'État qui ont été données de manière plus souple. On a libéré un peu cette possibilité au niveau européen, mais dans le domaine de la presse, elles doivent être également données en respectant le pluralisme. Et on a quelque inquiétude dans certains États de voir les aides ou les campagnes de publicité développées par les autorités nationales aller plus vers certains médias que vers d'autres. Donc il y a une difficulté économique. Il y a aussi une difficulté liée aux attaques de plus en plus nombreuses, pas seulement les violences contre des journalistes, mais aussi les attaques en justice. Parfois des journalistes qui se retrouvent face à toute une série de procédures à leur encontre pour bloquer un peu leur capacité d'action. On appelle les slaps de l'autre côté de l'Atlantique, et on essaie aussi de voir comment agir en la matière. Mais si vous posez la question de savoir si c'est un échec, bien sûr, mais je ne dirais pas un échec de la Commission. D'abord, je suis assez à l'aise pour en parler, je viens d'y entrer, mais c'est un échec des institutions. Voilà, c'était peut-être les précédentes, mais des institutions européennes comme de beaucoup d'institutions nationales. Chaque fois que vous voyez une détérioration de la situation, on ne peut pas considérer que c'est un succès, ni pour les autorités nationales dans l'organisation de la démocratie et des droits fondamentaux dans l'État, ni pour les institutions européennes. C'est pour cela qu'on essaie d'améliorer et de changer. Le rapport est venu de cela, d'une dégradation de la situation de l'État de droit, et cette idée de devoir en parler dès lors plus fortement partout à travers l'Europe, et pas seulement dans les institutions européennes. Et puis des stratégies. J'ai dit tout à l'heure, on peut évidemment faire un rapport. Nous devons mener des stratégies de procédure devant la Cour de justice pour stopper des dérives dans un certain nombre d'États membres, mais nous devons aussi mener des stratégies, par exemple, on en parlait tout à l'heure, pour des minorités. Je dis, on a une stratégie sur les Roms qui a été adoptée en commission. Dans les prochaines semaines, avant la fin de l'année, on parlait de la communauté LGBTI, nous aurons aussi une stratégie qui va être mise en place, mais donc avec des actions concrètes. Actions concrètes, soit de vérification de la mise en œuvre du droit européen et donc éventuellement des procédures d'infraction, comme dans tous les domaines, mais surtout des actions de soutien et des actions concrètes sur le terrain pour voir comment on peut développer une culture plus favorable à la protection et à la promotion d'un certain nombre de minorités à travers l'Europe. Donc voilà, mais le sentiment d'échec, chaque fois que quelque chose ne fonctionne pas, bien entendu qu'on doit se demander pour quelles raisons on n'a pas réussi à prévenir suffisamment tôt l'émergence de tendances qui vont à l'encontre des droits fondamentaux, de la démocratie ou de l'état de droit. Et le rapport, je l'ai dit tantôt, a cette ambition de vouloir, comme on l'a fait dans d'autres domaines, donner un avertissement plus précoce, un signal plus précoce dans les 27 États membres quand on détecte une évolution. Dans le domaine budgétaire et des réformes structurelles, le semestre européen, ça n'est que cela. Avant, on discutait des budgets quand ils avaient été adoptés par les parlements nationaux sous proposition des gouvernements. Maintenant, on en discute tout au début de la procédure. Et on essaie de voir dès le début s'il n'y a pas à corriger un certain nombre d'évolutions. Nous tentons de faire, la comparaison n'est évidemment pas parfaite, mais de faire un peu le même travail en ayant en permanence ce rapport qui sortira chaque année sur l'état de droit et qui tentera de détecter les dérives ou les problèmes avant qu'ils ne prennent trop d'importance. Mais il y en a qui ont déjà pris une importance très grande. C'est ce qui explique que nous avons des procédures sur base de l'article 7 encore sur la table du Conseil aujourd'hui.
Oui, je dois dire que le sentiment d'échec, personnellement, je l'ai prouvé pendant le mandat précédent à la Commission, mais je pense que c'est un échec, pas seulement des institutions, comme tu disais justement, c'est un échec pour la société, en effet, en général. I have 2 questions online. I would maybe collect a last round. I don't know how much time you still have, but maybe a last round of questions and replies. I see 2 there. 2 neighbors there, and 2 online. Take another one, yes.
Hi, good morning. First of all, thank you for being here. And I have a question regarding the budgetary conditionality proposal. I definitely see the potential effectiveness of such a proposal, but I wanted to know your opinion on how to avoid doubly punishing European citizens, because in countries where this could be an issue or where this could be applied, the European citizens are already suffering from the degradation of the rule of law, and I wanted to know, how to avoid punishing again these citizens, but also how to avoid sparkling feelings of the European Union letting them down in this context.
Thank you.
Good morning, and thank you for coming here today. Actually, my question is really related to the one from my colleague, and is, how do you think that this report or the conditionality between the EU budget and the respective rule of law can foster your skepticism in these countries that might be more affected by the reduction in the EU budget?
Thank you. I think we had another question here.
Hello, my name is Daniela, and I'm from Romania. Thank you, Commissioner. You were talking about the link between attracting foreign direct investment and the rule of law. Countries are now screening direct investment, but also investors are screening their countries. And the numbers, they show that investors, they lack confidence in particular countries. And also, after the termination treaty, there is a big problem with how to protect investors. So my question is, do you think that this report that the Commission released last week is a warning sign, or because it's a soft law, or should become like the economic semester with some concrete recommendations and possibly some sanctions? Thank you.
Thank you very much. I would now try to read 2 of our online questions. One says, good morning, Commissioner Reinders from Natolin. Good morning, Natolin. Thanks for joining. How can new technologies and artificial intelligence impact on the respect of the rule of law and basic judicial rights? I think this is a very interesting question, especially if you think of the facial recognition systems that are in place and sometimes apply some of the stereotypes that can be then complicated for the proceedings, judicial proceedings. And then the other one, est en français. N'y a-t-il pas un risque à trop vouloir s'immiscer dans les politiques judiciaires de certains États membres de participer à la montée de l'euroscepticisme au sein même de ces États? C'est une question purement politique, je dirais, intéressante à répondre.
So first of all, about the other mechanism about the conditionality between the rule of law and the funding of different policies of the MFF and the Generation EU now. Of course, we try to protect the EU budget. So we try to be sure that there's a real protection of the EU budget. I want to insist on one element. We have new procedure to protect the EU budget against frauds, abuses, and maybe conflict of interest, because till now we have had OLAF, administrative control, but from beginning of next year, end of this year, we will install the new European Public Prosecutor Office, EPPO, with the new Chief Prosecutor, Laura Kövesi, and for the first time it will be possible to launch investigations and prosecutions from the European level in 22 member states, because it's an optional system. And of course, we have the classical opt-out for Denmark, for Sweden, and Ireland, but we have also had an opt-out for Poland and Hungary. I don't know why, but from those two countries to don't take part in the EPPO. But it's a first protection. Of course, we need also to protect the budget against a general breach of the rule of law in one member state. And if we are doing that, it's not to organize a sanction against the beneficiaries of the different fundings. And so, to give an example, if you suspend or you stop the funding of the agriculture policy, it's not to organize a sanction on the farmers. If you have a breach of the rule of law in one member state, it's maybe not due to the farmers. It's an analysis about the behavior of the authorities. And so, in the proposal of the Commission, and we are working on it again, it was very important to think about other mechanisms to continue to finance the beneficiaries and the final beneficiaries of the funding. That means to impose to the member state to continue to fund, or to have a direct financing coming from the EU level. And so it will be a part of the discussions, because we have discussion about the scope of the conditionality, the procedure, what kind of majority, it's an important decision, and then what kind of possibility to protect the final beneficiaries. And that will be the most important element. But we try to do more, because we try also to help different kind of actors to promote the rule of law and to fight for the individual rights and the minority rights. And so again, we are financing some associations of human rights defenders. Of course, the goal is not to cut such a financing if we have a general breach of the rule of law in one member state. Contrary, we need to continue to, and maybe to do more. So it will be a direct financing. It's not so easy, I must say, because it's not the tradition of the Commission to finance directly those policies. It's all the time through the member states. But we'll have some proposals to avoid such a kind of problem in the way to organize the conditionality. About the trust, in fact, and the trust about the functioning of the internal market and the functioning of the investment policy from different companies in Europe in all the member states, it's true that we have received more and more remarks on that, because again, the independence of the judiciary, it's a real part of the problem. If you invest in another member state and your own member state, you need to be sure that it's possible to go to an independent judge if you have a problem with your partner, but maybe also with the authorities. I'm thinking about different processes, privatizations in some member states, and you take part in the process, but then you are maybe in a conflict with the authorities. So it's possible to have a real access to that. So we need to take care of that, maybe with some pressure again, with the report and other tools to improve the independence of the judiciary, but maybe also with new pressure like the funding. Is it possible to stop some funding to have another pressure? And you know that at the end, but the rules are not easy to apply, we have the Article 7, and we need to repeat that at the end of the Article 7, if there is a decision at the Council level, it's possible to suspend the voting rights from one member state. So it's not to exclude the member states from the European Union, but it's to exclude to the decision-making process. It's quite a huge sanction. And so now we need to find a way to be effective to rebuild the trust with the different tools. And of course, the best solution is to see a positive evolution in the independence of the judiciary. Again, I don't want to repeat all the chapters, in all the member states. And it's the reason why we need to use existing tools, maybe to create a new one with the conditionality, but also to go to the member states to explain what the problem is. And I'm going back to the question about education, and it's very important to explain what is it in the daily life of the citizens, of the businesses, and other actors, because in some ways it seems to be far from the citizen. When you are just speaking about checks and balances in the constitutional order, rule of law, it seems to be far from the reality. But when you explain that the rule of law is to be sure that you have the same equality, the equality for everybody in front of the law, and that you are sure that the law is in full compliance with some principles, and then if you have a problem with different actors in the society, it's possible to go to an independent judge, it's become to be more evident for the citizens that we are fighting for something for them and not that we are fighting for political debate with different member states and different authorities. But it's true that that's a real issue. And we have new concerns. It's also true about AI, artificial intelligence, and more than that about developments of new technologies and different kind of use of new technologies. I'm thinking about the expert systems, about learning machines and different kind of new elements. And to be concrete, we try to apply the same kind of set of principles with a protection of fundamental rights and protection of our values. 2 years ago, with the previous commission, it was possible to organize the so-called GDPR to protect the personal data and to try. It's exceptional in Europe, and we have seen the development in other parts of the world in the same way. But to say, of course, the data, it's an economic asset, but it's also a real issue if you look to the privacy, to fundamental rights, to discriminations, and so on. It's important to protect it. And we have huge discussions now with some partners in the world about that. But now we try to do the same with AI. We try to have a so-called human-centric approach. That means we try to see if it's possible to verify that we don't have any discrimination in the management of the data and the treatment of the data by learning machine or expert systems. Because, to be concrete, if you organize the recruitment of people on the basis of AI, that you are putting the data of the last decades for some functions in a company or in an administration in your system, in your application, of course you will have some bias, you will have some problems and some discrimination. To be concrete, for some functions, you will see that you have only data about men and maybe not about women. Maybe about some categories of people and not about some minorities in the population. And so we need to verify that there's no discrimination in the data themselves. And so it's the reason why we are working on the new legislative proposal for the beginning of next year about AI, including such a reflection on the risk of discriminations, the risk of problems for the fundamental rights due to that. Of course, we will think also about the safety of products using AI and the liability, because I said that all the time, if we have in the future more and more cars without any driver, so autonomous cars, in the case of an accident, you are sure on one thing, there's no driver who is responsible for the accident. But who is responsible? Is it the producer of the car? Is it maybe the developer of AI in the car? We need to discuss on this. But certainly the way to protect human rights and fundamental rights. But I want to add, in the justice system, I have said we need to insist on more investment in the member states about new technologies. But of course, is to help in the way to organize the functioning of the justice system, to use more videos, to use more new technologies to manage the different processes. But at the end, you need to have a human judge to take the decision. And there are some risks to see some ideas about the way that it's possible to use AI to take the decision without any action coming from human body. It's not true. At the end, you need to have human decisions, and so we are working also on it. There are some sectors with more risk than others when you are using AI. Mobility, I spoke about the cars, but also health, if you discuss, and justice, certainly. Justice, it's also a sector with risk, and so we need to pay attention to that. Alors, est-ce qu'on ne peut pas renforcer les eurosceptiques en étant trop présents? Je crois qu'on en revient à deux débats, en fait. Un débat sur les valeurs, je ne vais pas le refaire, ou bien on adhère à ces valeurs ou on n'y adhère pas. Évidemment, si des individus ou des groupes n'adhèrent pas à ces valeurs, je crois qu'on doit mettre tout en œuvre pour les convaincre, mais aussi pour les combattre politiquement. Et s'ils passent à des actions qui ne sont pas admissibles, y compris des actions violentes, les combattre aussi par les outils dont on dispose en matière de force de l'ordre et de système judiciaire. Mais quand on a un set de valeurs communes, on doit évidemment tout faire pour les préserver en les expliquant, en les diffusant et en combattant celles et ceux qui ne partagent pas ces valeurs, ou alors il ne faut pas les mettre dans les standards communs. Et c'est pour ça que je disais tout à l'heure, il y a une très grande marge de manœuvre dans l'Europe, parce que le deuxième débat que nous avons, c'est concept que vous connaissez, mais qu'on doit aussi vulgariser parfois, c'est la subsidiarité. Je prétends que l'Union européenne ne doit pas intervenir dans tous les domaines. Mais on le voit avec la crise sanitaire, peut-être qu'il serait bon que dans certains domaines de santé publique et de lutte en cas de pandémie, l'Union européenne intervienne dans les stocks d'équipements, dans le développement, on le voit maintenant, de vaccins. Si on ne se met pas ensemble dans l'Union, on n'a pas la capacité de travailler pour le développement des vaccins, mais peut-être aussi dans d'autres choses comme la coordination des politiques. Si vous faites une carte d'Europe avec des régions à risque et des régions qui le sont moins, ce serait quand même bien qu'elle soit la même dans tous les États membres. Donc voilà des éléments sur lesquels on peut travailler. Mais est-ce que ça veut dire que l'Union européenne devrait décider de tout en matière de santé? Certainement pas. Et en matière de justice, la même chose. Je le disais tout à l'heure, la législation civile ou criminelle n'est pas du tout la même dans les États membres. Le tarif criminel n'est pas le même. Les cultures sont différentes, les approches sont différentes. Jusqu'où laisse-t-on une certaine autonomie? Ce que l'on vérifie dans le rapport, c'est l'indépendance du système judiciaire, c'est sa qualité, c'est son efficience. Là, je crois que personne ne peut douter que le recours à une autorité judiciaire n'a de sens que si cette autorité est indépendante et bien sûr de qualité et efficace. Si l'autorité judiciaire n'est pas indépendante, mais ça ne sert à rien de l'organiser. Imaginez que l'on vous refuse une décision dans une administration. Si vous devez aller en justice pour contester cette décision, mais que la justice n'est pas indépendante de l'autorité, vous connaissez déjà la réponse. Et donc, à quoi ça sert d'organiser même un système judiciaire si les différents pouvoirs ne sont pas séparés et ne sont pas indépendants les uns des autres? Et on a le même débat entre Parlement et gouvernement, bien sûr, mais entre l'autorité judiciaire et les autorités exécutives et législatives, c'est évident. C'est cela que l'on vérifie. On ne veut pas entrer dans les décisions individuelles. D'ailleurs, la Commission répète régulièrement qu'elle ne commente pas les décisions individuelles. Il faut utiliser les recours, y compris européens, devant la Cour européenne des droits de l'homme, qui existe, par exemple, ou devant la Cour de justice sur l'interprétation du droit européen. Ça, c'est le fonctionnement des cours et tribunaux. Mais leur indépendance, leur qualité, leur efficacité, leur efficience, c'est évidemment un élément que l'on doit pouvoir vérifier. Alors, si ça renforce un certain nombre d'euroscepticisme, là, on entre effectivement dans le débat politique, et il ne faut pas hésiter à affronter ces débats. Moi, je terminerai en vous disant que dans une autre vie, dans une vie antérieure comme membre du Conseil, j'ai souvent dit à des collègues qu'une des difficultés que l'on rencontrait dans les institutions, c'est cette idée que quand une décision prise au niveau européen est bonne, et plutôt positive pour les citoyens, dans la conférence de presse qui suit la réunion du Conseil, elle devient nationale. Et si la décision est un peu plus compliquée à expliquer, alors qu'elle a été prise par les mêmes personnes, c'est Bruxelles. Et je dis Bruxelles parce que...
Ça ne marche pas en Belgique.
Et j'ai toujours dit, moi, malheureusement, quand j'étais dans ces fonctions nationales, je ne pouvais pas utiliser l'argument parce que les institutions nationales et européennes sont dans la même rue, à Bruxelles. Et donc, c'était évidemment difficile de dire c'est Bruxelles parce que ça ne veut rien dire en Belgique. Mais voilà, pour répondre à votre question sur la Belgique. Mais je crois simplement qu'à force de mettre l'accent sur la responsabilité européenne dans des politiques qui ne sont pas européennes, comme la politique de santé que l'on vient de vivre dès le début de la pandémie, où chaque fois que des décisions sont compliquées à prendre, on renforce évidemment l'euroscepticisme. Donc si je peux vous donner un conseil dans peut-être vos futures fonctions, quelles qu'elles soient en Europe, si vous participez à des décisions européennes, assumez-les. Assumez les décisions, bonnes ou mauvaises, mais surtout positives ou plus difficiles à expliquer, assumez-les, mais montrez tout ce que fait l'Union européenne dans son ensemble et tout ce qu'elle a la capacité de faire. And so it's very important to be proud to exercise a function at the European level, but it's also very important to explain what is it and what is it not. And that's maybe one of the most difficult issues when you discuss with some members of the European institutions. And they are taking care of a real national interest in many discussions, but also they are taking care to show that the negative impact is coming from the European institutions and the positive one from the national institutions. And that's maybe a real reason why we have seen so negative evolutions in the last years and decades. And I don't want to open the debate. It's maybe for our next discussion with you about the Brexit.
Thank you. Thank you so much for really sharing with us all here in Bruges and in Natolin so much, not only of the first ever Rule of Law report, but also so many other insights on the work of the Commission and on your personal views also on the European Union and the institutions. I have to say, Commissioner Reinders was saying exactly the same things on the European Union when he was having national functions. So this is also something I think that is relevant to notice, the consistency of positions expressed when you have national responsibilities and European ones. And I think this makes of him a remarkable commissioner and someone we are proud to host here in the College of Europe. We take it as a promise. We wait for you for further debates in the coming months. I think it was an excellent start for our academic year. I think our students were eager to get to business. And I can't imagine of anything better than this to start our conversations with high-level guests. It will be one of many, I hope. This is also an invitation not only for you, but also for all your colleagues back in the Berlaymont to join us anytime, including when red or orange zones get complicated, because Brussels to Bruges is not that difficult so far. We'll wait for federal guidelines to be developed on that, but hopefully that will stay safe. I would like to thank you really for joining us. Thank your team for having facilitated this. But I'd like also to thank the assistants, the departments, the director of study that, as you might notice, is not here with you today due to an health need to stay home today. She regrets not being here very much, but it was giving me the opportunity to benefit from this excellent opportunity. And I would really like to thank also very much our colleagues in Natolin that have been joining us and all students that have been following this conversation from their rooms. Merci beaucoup encore une fois et à la prochaine fois alors. Et congratulations et bonne chance pour la continuation de ce processus sur l'état de droit en Union européenne. Merci beaucoup encore.
Merci beaucoup.